Are you a property manager or landlord in South Dakota struggling to navigate the complexities of the eviction process? You're not alone, and we're here to help. Welcome, Loopers. It's Galena with Door Loop. Today, we will be diving into the eviction process in South Dakota. It may vary from county to county, but for the most part, it's the same general eviction process. Send an eviction notice, fill out the forms, serve the tenant, attend the trial, and wait for judgment. Every eviction process is different and dependent on the lease or rental agreement signed by the landlord and the tenant. There's a need to exercise meticulous file keeping to avoid errors that could be exploited by the tenant. A landlord is advised to have a written lease because it clarifies a lot of possible violations. A written lease also dictates actions that may be taken by the landlord should the tenant violate any agreements. Sometimes, a South Dakota eviction can be referred to as forcible entry or detainer action. This video is a summary for landlords to refer to when evicting a tenant. Remember, if you have any specific questions, don't hesitate to contact an attorney. Get our guide to the eviction laws on the go from Door Loop's Landlord's Guide series. Click the link in the description. Now, let's dive in. Eviction reasons. Non-payment of rent. According to South Dakota law, a tenant has failed to pay rent on time if they have not paid rent a day past its due. For example, if rent is due on the 25th and they haven't paid rent on the 26th, then a landlord can evict the tenant for non-payment of rent. A grace period may be available if stated in the lease or rental agreement. This allows the tenant to catch up on the rent and allows them to pay any rent that is still due. However, a landlord is under no obligation to let the tenant pay rent they may owe unless there is a grace period for late payment of rent in the lease or rental agreement. Instead, the landlord may give a second chance at paying rent if they wish to do so. Before they can start the eviction process, a landlord must give the tenant an official written 3-day notice to quit. If the tenant fails to vacate the rental unit after the 3-day notice, the landlord may continue filing for a forcible entry and detainer action. Oftentimes, if the tenant manages to pay any past due rent before being evicted, it will lead to a termination of the entire case. Violation of the lease or rental agreement. A tenant can be evicted for violating the terms of the lease. The lease and rental agreement has to be upheld by both tenant and landlord for the entire duration of their stay. Lease of the rental agreement may vary from tenant to tenant. If a tenant violates any terms of the lease agreement, the landlord must issue a notice to quit. Landlords are not legally obligated to allow the tenant to do any repairs before presenting them with the notice. Lease violations may include damage to the rental unit, smoking in non-smoking areas, keeping pets in pet-free properties, etc., and conducting illegal activity within the rental premises. South Dakota law does not state how long of the notice period a landlord has to give their tenant for violating the lease. Landlords are advised to give tenants an appropriate notice period. If the tenant remains on the property by the end of the given notice period, then the landlord may continue with the filing for a forcible entry and detainer action. False claims of needing a service animal inside the rental unit. A landlord reserves the right to evict tenants who have been dishonest with a disability that supposedly requires a service animal. Tenants charged with the false claims of needing a service animal cannot correct them. They have to be given a written notice to quit and vacate the property before being evicted. South Dakota law does not specify how much notice a tenant must receive before the eviction process can begin. Landlords are advised to give tenants an appropriate notice period. Sale of rental property. Sometimes a buyer takes interest in the rental property but does not wish for it to be rented out. In this case, the landlord must give the tenant a 3-day notice to quit. Should the tenant remain in the rental unit after 3 days, then the landlord can continue to file for eviction. Non-renewal of the lease after the rental period ends. In South Dakota, landlords cannot evict a tenant or force them to vacate the property without probable cause. As long as the tenant does not violate any rules, they can stay until their rental period ends. But if they stay in the property even a day after their lease or rental agreement ends and they have not arranged for renewal, landlords can issue a written notice to move. A landlord must issue a notice to quit. The amount of notice time they receive depends on the length of their tenancy or 30 days, whichever is shorter length of time. Should the tenant remain within the premises after the notice period, the landlord may continue to file for eviction. For your own South Dakota lease agreement, click the link in the description to download a template along with many other forms. Filing a complaint. How to file a complaint. The eviction process can only begin after the issuance of the appropriate eviction notice. Enough notice time must have been allowed before filing for eviction. The eviction process is as follows. Proceed to the justice court the rental unit belongs to, file a complaint, and pay the fees. Timeline. It takes about 3 to 30 days from the issuance of the notice to vacate or quit. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template or create your South Dakota eviction notice by clicking the link in the description and using a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want to do is go to court and only then find out that you did the first process incorrectly. Serving the tenant. How to serve a tenant. The third step in the forcible entry and detainer action is to serve the documents to the tenant. The summons for the eviction hearing and the complaint must be given to the tenant within 30 days of the day it was issued by anyone authorized by South Dakota law. The authorized server, usually the sheriff, constable, or anyone uninvolved in the case, has to deliver the summons and complaint at least 2 times. Each service attempt has to be 1 week apart. For the first attempt of delivery, there are 2 methods available. Personal service. The authorized server delivers the summons and complaint to the tenant in person. Publishing. The authorized server publishes a copy of the summons and complaint in the local newspaper. For the second service attempt, there are another 2 methods available. Substituted service. If the tenant is unavailable, a copy of the documents may be given to someone living with the tenant inside the rental unit. Posting and mailing. The authorized server leaves a copy of the documents for the tenant. It can be placed in a secure and visible position by the entrance of the tenant's rented property. When using this method, the official also has to mail a copy to the tenant. After serving the summons and complaint, a tenant must file a written answer in court should they wish to dispute the claims of the South Dakota eviction hearing. They have to file an answer within 4 days from the date they received the summons. But if the summons was published in the local paper, they have 1 month from the date it was published to file an answer. Should the tenant be unable to file an answer before their deadline, they can file for a postponement called continuance. That lasts no longer than 14 days. If the tenant fails to file an answer, then the judicial officer may decide to award judgment in favor of the landlord without the need for an eviction hearing. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. In this step, the landlord has to provide a strong argument backed up by solid evidence against the tenant. Should the tenant fail to show up to the hearing, the landlord wins by default. Timeline. Eviction hearings are scheduled as early as 2 days after the tenant files their written answer in court. Getting possession. After the landlord wins the case, South Dakota state law does not specify how long it takes for an execution for possession to be issued. Landlords are advised that this may take a few hours to a few days after they win the case. An execution for possession is a court order that tells the tenant they have to move out of the premises, or else they will be forcibly evicted by the authorized officials. It is usually the final step a landlord takes before they receive their rental unit back. Next procedure if the tenant disagreed and replied. In the state of South Dakota, a reply from the tenant is necessary for a court date to be scheduled. The earliest a court can schedule a court date for the eviction hearing is 2 days after the tenant files their written answer to the court. During the eviction hearing, the landlord needs to support the claim with evidence and show it during the hearing. This could include, but is not limited to, the following: copy of the deed and lease, rent receipts, rent ledgers, bank statements, witnesses, and photo and video documentation of the violations, correspondence, etc. Move-out process. Once judgment is passed in favor of the landlord and the execution for possession is enforced by officials from law enforcement, the tenant has to move out immediately since there is no clear time frame provided by South Dakota state law. The only specification made is that the officials can only forcibly remove a tenant from the rental unit during the daytime. Only the sheriff or the appropriate authorities are allowed to evict the tenant by force. Even if the landlord wins the case, they are not allowed to engage in illegal methods of eviction, or else the eviction process may may be overturned. The state of South Dakota does not specify what to do with the tenant's belongings. If any belongings are left behind, landlords are advised to contact the tenant and give them a reasonable time period to claim them. After the time period has passed, the tenant's property can be sold or disposed of. Timeline. Tenants must vacate the property as soon as judgment is passed in favor of the landlord, because South Dakota does not specify a time period for officials to follow. South Dakota evictions process timeline. Below is the average timeline for a complete eviction process. This timeline does not include special cases such as requests for an appeal or continuance. Showing evidence. How to keep good records. If the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge. This part can make or break your entire eviction requests in the event of a dispute. You can stay organized by keeping a physical paper trail. This gets very hard to search through, takes up a lot of storage space, and can get lost, damaged, stolen, or burnt in a fire. So it's important to keep them in a safe place. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other option that is easily searchable. PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is used best when you also scan every document into your software. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, showing the terms of the agreement when rent is due, and any penalties for late payment can be useful to your court case. All payments, showing all previous payments, how they were normally made, check, credit card, ACH, etc., and what date they were normally paid on. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also, show any fees your bank may have charged you and any penalties you are owed according to your lease agreement. All messages. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, it's important to show these. While it may not be needed, it can be useful to show that the tenant was aware of the whole situation. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you are evicting a tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's safe to say you will normally win this dispute. Video. If you don't catch them in the act, the next best thing is to record a video with your phone of any damages of the lease violation. Pictures. They say a picture is worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. Lease terms. Once again, show the court the entire lease agreement to show any violations from the tenant. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. Before I go in to talk about self-help evictions, don't forget to like, comment, and subscribe for more amazing content. Self-help evictions. Examples of illegal self-help evictions include changing the locks, taking the tenant's belongings, removing the front door, or turning off the heat or electricity. Many states specify how much money a tenant can sue for if the landlord has tried to illegally evict the tenant through some sort of self-help measure. Some state laws also provide a tenant's court costs and attorney's fees if the tenant successfully sues the landlord, and/or give the tenant the right to stay in the rental unit. Thank you for watching this video. For more valuable content, join our exclusive Facebook community with the link in the description. And to learn more, feel free to check out these videos. Thank you and have an amazing day.